So today is the PRS policy chat, what's next for agents and landlords. And as usual, and as always, today is for general information purposes only. It shouldn't be construed as legal advice or official guidance. And I'm delighted that today we are joined by David Cox, who's well known to so many of you across the industry, who's the Legal and Compliance Director at Rightmove. David, thank you so much for joining us. Would you like to give everyone a brief intro, please?
Good morning, ladies and gentlemen. Thank you very much for joining us. And I hadn't quite realised that I'm wearing the same clothes as was in my photo. So yes, I'm Rightmove's Legal and Compliance Director, having been CEO of Arla Property Mark for the last almost 7 years before I left last year. So we've got a really exciting day today. I think loads of changes for anybody that actually watched my webinar on Rightmove last week. Things have obviously changed a little bit since then. Nothing like a good government announcement to keep us all on our toes. So today it's going to be different content, different topics, and lots going on as always in the sector.
Brilliant. Thank you, David. And thank you to everyone for joining us today. So the topics we're going to run through today are electrical safety standards, the rules on possession, through which we're going to look at the breathing space rules, as well as what's happening with furlough, PRS energy policies against the backdrop of COP26 coming up, future developments in the sector, and then time for Q&A. So once again, if you have any questions, comments, thoughts, or insights that you would like to share with us as we go through this, please do put them into the Q&A button. So starting with electrical safety standards, David, what are the latest rules and key dates for existing and new tenancies?
So I think we all know that we are very much approaching that deadline now. It's the end of this month. What is it? It's the 16th of March. So we've got, well, 15 days to go now until the regulations and the backstop date kicks in as of the 1st of April. So technically, under the regulations, all private rented properties require an electrical installation condition report, an electrical safety check to be carried out. It was on new properties since June last year, but it's now on all existing properties. It's the backstop date, similar to the PRS energy efficiency regulations that we're going to be talking about a little bit later, Raj. So they need it. There are a few situations, and I wouldn't go as far as calling them exemptions, but where you can't get into the property because the tenant is refusing consent, which will be understandable in the case of coronavirus at this moment in time and the pandemic. You're not going to be in breach, but you are going to need to get it sorted pretty quickly. So I would suggest this is kind of your 2-week warning. Unlikely to be able to get them at this point in time before the deadline because the supply chain is just overly burdened with millions of properties needing EICRs. But that is what the deadlines are, and significant potential fines if they do actually enforce the law.
Thank you. And so I think you've already touched on the next bit, which is, are letting agents and landlords prepared? From our customer base more broadly, so we work with thousands of letting agencies. Not all of them are prepared, and I think a reasonable proportion have expected the deadlines to push out, so for there to be a moratorium or an extension, which just isn't forthcoming. So what are you seeing, David?
Certainly I'm not hearing anything out of government that is indicating that they're going to extend that deadline. I suppose their argument is you've had best part of 12 months now to get your house in order. They're not really factoring in COVID and the implications that the pandemic has had on people. But at the same point, for the vast majority of the time that we've known about this law, the industry has been released, so people have been able to go in. So I suppose this is kind of a mashing of multiple different pieces of law and guidance coming together. So you've got the hard and fast law that says backstop date 1st of April, fines if you're prosecuted for not having an EICR. So that is kind of one law, but you've then got to factor it in alongside the coronavirus legislation that talks about, one, local authorities should be taking a pragmatic approach to enforcement, and two, that where somebody is refusing entry because they don't want tradespeople traipsing around their house during the pandemic, that's acceptable as long as you are taking reasonable measures and reasonable precautions in order to make sure your property is compliant. So what I would say, is that this is probably one where you will be okay if you've got a tenant refusing, as long as you've made reasonable efforts, as long as you can document those. But because this is a safety one, and it's a big safety one, it's electrical safety, same level as gas safety. What is a reasonable time is probably shorter than if it was a different piece of legislation. So maybe check once a month that they still won't allow you in to do it. Make sure you document it, make sure you've got file notes, so that should anybody, the local authority, ever come along, then you've got something there to say, well, this is what we did. These are the dates. This is what the tenant responded. We will do it as soon as the tenant allows.
Absolutely, and I think sort of hammering home the point on documentation. It's not just doing the right thing; it's being able to show that you have tried to do the right thing or done the right thing is absolutely imperative. And I think it's also worth noting that the requirement for new tenancies has been in place for several months. So
Yes.
There should have been an increasing, I say should have because I'm not sure quite to the extent that this has been happening, but there should have been an increasing number or proportion of rental properties in the PRS which have up-to-date EICR reports. For anyone who's interested, we've done a flowchart on this with JMW Solicitors with David Smith, which will be available on our website if you're interested in quite how the timings work. But the upshot is, if you haven't got yourself sorted, please do so immediately, notwithstanding the fact that you may struggle to get contractors. And that sort of supply, the lack of supply is something that we're hearing quite a lot about. Is that something that you've come across, David?
So I think that's a really important point and something that has been raised with government several times. I remember I sat on the electrical safety working group that was advising on these regulations, and somebody else on that group, a well-known business, said, look, we're the largest provider of these in the country. We can't do it in anything under than 18 months. The supply chain just doesn't exist. So then saying, oh, well, actually the industry's only got 9 months, which is half the time that they were told would be required, then add in the pandemic as well, it's not massively unsurprising that I know I'm expecting almost widespread non-compliance with this particular one, simply because people haven't had time to get it sorted. It was only a small window. But at the same point, that isn't an excuse. We have had a year. I know a lot of people were putting it off to the last minute and then trying to get them now, and obviously there's a massive backlog. Once again, as long as you can evidence that you have tried, I can't guarantee it's going to protect you, because if you didn't start until February or March, an enforcement body would say, well, you knew about this last year. Why didn't you start looking and doing something about it in August? Which is a fair argument and a fair assessment. But if you can say, yeah, okay, but we've sorted it now, we've got it booked in for late April, early May, it should give you a certain degree of protection.
Excellent, thank you. I can see a series of questions already coming in on EICRs. And we're going to wrap up all the questions at the end, so in the final 15 minutes. We'll get through as many as we can. The next topic is large, complex, interconnected. I think it's interesting that we are, so I view lockdown not as a date, but a state. So there was no date on which lockdown started, but the diminution in social contacts was already well in place a year ago. And it was a year ago today that Matt Hancock said to Parliament that social contacts should be minimised or avoided. I can't remember which term he used. But we're a year into this, and there are 3 interlinked issues that I see that I'd love to go through with you, David. The first is possession, I guess more broadly. So what happens and when might landlords be able to recover possession of properties? The second is the respite scheme. So what happens with debt recovery? And the third interlinked point is furlough. So there's always been this impending cliff edge of furlough, which continually gets extended, but the 3 issues go together. So are tenants able to pay their rent? What happens if they can't? And if they can't, are their landlords able to recover possession? So David, I guess starting with the very top, what are the current rules on possession and when might landlords be able to recover?
So this is what I mentioned when I said a few minutes ago that things have changed since my Rightmove, my News Hour webinar from last week, when I said, well, we've got less than a month to go, haven't heard anything. Literally later that day, I'm not sure whether they were listening to the webinar, but literally later that day, they were like, yeah, we're changing things at the end of the month. So this is literally, it's a few days old now. They've now published the guidance, so it's available on gov.uk for anybody that really is that desperate to look at it. But effectively, the evictions ban, so the bailiff ban and the 6-month notice period, all extended until the 31st of May. We then got a government announcement that says there is going to be tapering thereafter to back to normal. I'm afraid at this point, the guidance doesn't give any idea or explanation of what the tapering is going to be. But again, as I said last week, it would be unusual to go from the 6 months to 2 months automatically, because if you're partway through a 6-month notice period, you just cancel the notice and reissue it at 2 months. Yeah. And therefore it somewhat defeats the concept of the 6-month notice period. So I think that's why they're talking about there's going to be tapering once we come out of the eviction ban of the 6-month notice period. So key date, 31st of May. All the exemptions are still the same. So the illegal occupation, false statements, rent arrears over 6 months, antisocial behaviour, including rioting, and obviously the death of the tenant. So that's all still in place. No changes. They're just extending the deadline. What I would remind everybody as well is if you do have an order for possession, once that bailiff ban is lifted, excuse me, once the bailiff ban is lifted on the 1st of June, you then still have to give the 14 days. So effectively, we're talking about the first possible date for a bailiff to evict is looking like probably the 15th of June at this point in time, which I do believe is a Tuesday.
And there are what I would describe as gummed up courts as well. So there is.
I think that's yeah. That's a good way of putting it. Well, I suppose
backlog.
Yeah, as you would expect. If you think about the fact that the courts are basically being closed for a year now, and I think how many possession cases, both landlord in the private rented sector and landlord in the social rented sector, that would have gone through during a 12-month period, they're just sitting there backlogged in the courts. The government have made clear that the prioritisation of possession cases is going to continue until that backlog is cleared, and it's why they're encouraging people to go down mediation, look at the breathing spaces scheme as well, that will, I suppose, one is to try and alleviate the pressure on the court, and also try and come to more amicable solutions.
And so I was sort of dialing it back to the core focus of this webinar. So from a policy perspective, the government's policy has been to avoid homelessness. And its method of doing so has been to provide financial support for a subsector of society, and not obviously they haven't managed to reach everyone through that, and then also to provide a preventative measure for recovering possession. This is against the backdrop of their wider policy. I think is moving. My view is moving against Section 21. More generally. So how if you're a speculating or betting man, how would you see these two coming together as the taper off of the current regime comes into effect, and then and they move towards abolition or weakening, depending on view, of Section 21?
I think you're absolutely spot on that one there, Raj. I think they are almost using this as a test bed for the ending of Section 21. What will happen if they ban Section 21? So, yeah, I think we've got a couple of things kind of clashing together here. We've got the pandemic response. We've got, and as you've said, it's a two-tier. It's the financial aspect of the furlough coupled with the preventative actions to remove tenants from properties. And I would say this isn't something that just affects private landlords, which is new. Most of the time they pass laws that just affect private landlords. This impacts the social sector and actually mortgage companies and repossession in exactly the same way, because it's not just a ban on private landlords seeking possession. Mortgage companies are, and the social landlords are in exactly the same bed that we are as well. I think from a policy perspective, we can clearly see the government's direction of travel. They've made a very public pledge to ban Section 21. So we've got to kind of expect that that is coming in the not too distant future. They've already announced that it is going to be in the Renters Reform Bill. Obviously, the pandemic has slowed things massively in relation to that. But certainly the last time I spoke to the Housing Minister, he's still very keen that that is going to go ahead. So don't think it's disappeared. it's a while away, and I don't think they're going to be able to keep the coronavirus rules in place long enough to just then simply replace them with the Renters Reform Bill. So we will go back to normal, to go back out of normal again, if that makes sense. But it's very much seen as the prelude. And it's why we've got things like the Breathing Space Scheme. It's why they're encouraging mediation. But I think what is really important to point out at this point is that we are, to a certain extent, coming to the end of the apocalypse. And actually, rent arrears are nowhere near as high as you would expect when you think about the level of people that have been furloughed, that have lost jobs. Certainly the evidence, and I do accept it's anecdotal from what agents have told me, is that it's not actually as high as they were expecting. It's higher than normal, obviously, but it's not massively high. What it is individual properties generating large rent arrears, and the difficulty of then getting those people out, rather than widespread across the board, everybody's kind of in rent arrears. And looking at the budget a couple of weeks ago, what was it? It was 240 billion, I think, that they have put into these the anti-pandemic response. So actually sorting it out, it's a huge amount of money. And I know when I was at Property Mart, our main campaign was keep the rent flowing, because we very much took the view that if tenants can continue to afford the rent, agents can continue operating, landlords can continue operating, rent arrears aren't building up, which then are massively impacting credit ratings on those tenants going forward and their ability to obtain credit, which then has financial implications long into the future. And it's certainly in the early days of the pandemic response, where the FOLO scheme had gaps, I remember talking to officials in the Treasury and in MHCLG, and they were very happy to close those gaps. So there shouldn't have been that many people that fell through the gaps. I do accept there were a few. And that's why, for those people, they increased universal credit. And I think in the budget last week, they said that they're increasing it by an extra £20 a week for a period of time. I can't quite remember the exact time off the top of my head, but for a period of time. And then on top of that, they are giving £500 in tax credits. Just give me 1 second and I'll just remind myself what it is. So yes, £20 uplift in universal credit is being extended for a further 6 months. So at least that will benefit those that have fallen through potentially the furlough scheme.
And so then from a policy perspective, the government is banking on a fast recovery, because without that sort of rebound, or the spending of pent-up consumer demand, there will be an employment gap, at which point the rules on possession will come back under the microscope, because there will be increasing arrears. Anecdotally in the market, and this is nothing new, this has been pretty much a year to the day since people started paying more attention to rent guarantee insurance and the like. And I know as a landlord that has been absolutely key, and something that agents we work with have been talking about. So for the people on the call, they will know this inside out, but it's not just on one side recovering possession, it's also about mitigating the potential loss to your landlord client base.
I think that's a really good point, actually, Raj. When the rent guarantee has existed for a long time, some landlords have liked it. It reduces their risk, and for those that have a low risk appetite to rent arrears, it's a great product. It does work. I think going forward, it's going to become more of a sort of mainstay of the industry, in the same way that there's no requirement to take out contents insurance or buildings insurance, but it's in some mortgages, but people do it because it's just how they mitigate their risk. And I think rent guarantee insurance is one of those that is probably soon to have its day and to become a mainstay of the industry, be it with individual landlords taking out the policies themselves on their rental properties, or I'm seeing an increasing number of agents are incorporating some sort of rent guarantee, rent protection into their fully managed services. So it's an added bonus. So it might be something for agents to, what is my USP? What can I give above? So maybe some of my competition, that might be one of the options. And if I can make a terrible plug, Van Mildert has just issued its new rent guarantee product, both direct to landlords and via agents as well. Please do contact Van Mildert for more information.
Other providers are available. And so I'd like to sort of bring this back to the breathing space and the debt respite scheme. So as furlough unwinds, as the courts ungum, as possession is possible again, there is another factor that agents and landlords need to consider, which is the debt respite scheme. Would you be happy to give a brief overview of how that works, and I guess most importantly, what this really means?
Sure. So the debt respite scheme, what is being known as the breathing space scheme, it kind of does what it says. It's providing breathing space for people that have fallen on very hard times. So there's two types. There's the standard scheme and the mental health crisis scheme. I would say they're not in force yet. They come into force on the 4th of May this year. So they're available basically to anybody that is in problem debt. It gives legal protections from creditors for 60 days. So it pauses enforcement action. It pauses contact from creditors. So if somebody does have a breathing space scheme, you're not allowed to chase for possession. So that is one of the key things. It covers a variety of things, including utility bill arrears, for example, payday loans, personal loans, store credit, credit cards, and of course, rent payments. What will happen? It has to be given by specific people. So either a debt counsellor, a local authority, or the insolvency service themselves. There's a register of these, or there will be a register of these at the insolvency service. So you will be able to check if you are told you've got one. And I suppose effectively, you must not serve a notice of possession during that time. You can't really contact them about their debt and their arrears that are built up. What I would say, though, that it doesn't prevent them still being liable for rent. So if they have a breathing space scheme, it pauses what is already built up. It doesn't pause ongoing liabilities. And therefore, if they get a breathing space scheme, you can't act on what they have done and what is the sort of the nature of the breathing space. So the rent arrears in our case. But they're still liable to continue paying. And if they keep building up those rent arrears during the breathing space scheme, you can apply to have the breathing space scheme removed. Now, there is quite a lot of guidance on this. I think more is going to come out as we get closer to the 4th of May inception date, enforced date. But that is effectively what the scheme is talking about and what it's going to do. It is that 60 days pause so they can basically sort out their finances, get in front of a debt advisor to look about how they restructure their debt and start paying it down. But they have to then maintain their commitments, their ongoing commitments during that breathing space scheme. Does that make sense? It does.
I'm going to, and I appreciate you didn't make the policy, but I'm going to describe it as horribly complex in terms of its operation, and one that I would describe more as policy on the fly rather than a joined up effort between everything else. So it's a recognition that there is a cliff edge coming and there may be people who need additional time beyond that cliff edge, but with each of these grey areas, it doesn't feel like it's addressing the underlying challenge, because if there is a challenge for 60 days, there may well be a challenge thereafter. And I am unconvinced that 60 days will be sufficient to deal with the severity of some people's situations. So I guess from our perspective, it's just hopefully making the audience, the lettings professionals, aware that this is coming, and they shouldn't be surprised if it starts to impact upon them. But quite what the impact will be for the people who are intended to benefit with a 60-day respite, it's better than nothing, but it probably doesn't address the underlying causes.
Yes, effectively, it may well just push them a little bit further down the line, but it may at the same point, because they have to actively sought help in order to get one of these, they're in a better position. They've accepted that they are in a financial problem and they have gone to seek help. So by making that first step, maybe giving them those 60 days, it might help turn things around. What I would say for the mental health one, so the 60 days is the standard breathing space scheme for financial difficulties. The mental health crisis one is for 30 days beyond the end of the mental health crisis. So that is kind of time unlimited. It will be for the duration that the person is, well, the exact term is it lasts as long as the person's mental health crisis treatment plus 30 days. So it is slightly different. And that, again, somebody will need to register that. So you'll be able to evidence that they do have either a standard breathing space scheme or a mental health crisis breathing space scheme on the Insolvency Services website.
Thank you. And for those agents out there who have tenants or tenants with arrears building, this may be an opportune moment to start educating your landlord base about these schemes. If you think A, it would add value to them, and B, it's something that it may face, maybe not for your entire landlord base, but for those properties with arrears accrued over this period, it might be an opportunity to engage with your landlord base. Love to come on to the next topic. And just before we do, as a reminder, please do send through any questions, comments, insights that you have through the Q&A on the Zoom panel. We have a lot that have built up already, and we're going to do our best to work our way through them in the final 15 minutes of this webinar. The next topic is PRS energy policies. So I have a theory, and often my theories are wrong, but my theory is that the property sector is behind the curve on the E, the environmental of ESG, so environmental, social and corporate governance, but it is rapidly going to come to the fore, not least because of the net zero targets that the UK have set, and the fact that a reasonable proportion, or a large proportion in fact, of the carbon footprint comes from properties. With the UK hosting COP26 in November in Glasgow, not in November, in November in Glasgow, this is going to be across the news, and I think we can expect to see a swathe of government policies, and in fact possibly changes in policies to support the move towards net zero. And so just sort of diving into that, there are lots of things that the government is doing or mooting, including raising the EPC requirements. They are mooting banning gas boilers by the mid-2030s. It feels like the property sector is a tool that the government will leverage in its journey towards net zero. What do you think is likely to come, and how do you think it is going to affect the residential letting sector?
So I suppose this one is one that has been sort of slowly creeping up on us since, I think it was 1992 with the Kyoto Protocols. And we've had this target, the 2050, 80% reduction in greenhouse emissions by 2050. So we've known it's been coming now for the best part of 30 years. We're basically halfway through this process. We've got 30 years to go. So the housing sector, the property industry was always going to be one of the big areas of focus because, as you very rightly pointed out, we are one of the worst for greenhouse gas emissions. Not from anything that we do, but because particularly in this country, we've got a lot of old housing stock that wasn't built to thermally efficient standards because the standards didn't exist. And therefore, that is why they are looking at existing properties. It's why there are such high energy efficiency requirements on new build properties through building regulations. So we're naturally going to be a target because we've basically got to reduce our carbon emissions to zero in order to reach those 2050 targets. So yeah, you're absolutely right. They're talking about banning boilers, banning gas-fired boilers. Not quite sure how they're going to manage that one, especially when you consider that that is how most people, certainly outside of London anyway, heat their houses. So that is a big one, but they're looking at the private rented sector, which always has statistically lower average EPC ratings than the other two tenures. I do completely accept that is because, particularly in the case of the social sector, they've had billions and billions of pounds of government funding in order to improve their energy efficiency, whereas the private rented sector hasn't. But we are going to be a target. EPC band C by 2025. For new lets, existing lets, backstop date, just like the electrical rules, April 2028. We've got the Green Homes Grant. I don't know whether that's another question, Raj. So do you want me to?
Well, I think the minimum EPC ratings to me is the stick. You cannot let a property unless it reaches a certain standard. And in theory, at least, the Green Homes Grant is the carrot to encourage the changes that are necessary to reduce the carbon footprint of homes. But how effective do you think the Green Home Grant will be? And I guess secondly, what can letting agents and landlords do now to start preparing for what's coming down the track by way of the stick?
So I think you've got some great points there, actually. One, the Green Homes Grant. It's free money. Why wouldn't you take it? They're going to be increasing the cap. So I think they're increasing the cap to £10,000. So at the moment, it's £3,500 to get the property up to an EPC Band E under the minimum energy efficiency regs, the MEES rules. They're looking at increasing that to £10,000. And this is, let me make sure that I've got this absolutely right. This is vouchers that will cover 2/3 of the cost of eligible improvements up to a maximum government contribution of £5,000. So 2/3, £5,000. It's looking at effectively up to £7,500. They will cover 2/3. If the works are going to cost more than £7,500, it's capped at £5,000. And this is available now until the 31st of March next year. So 31st of March, 2022. So in terms of what should agents and landlords be doing, do it now, because this is free government money and it's going to contribute 2/3 towards the cost of the works, as opposed to being beaten with a stick come 2025. So you might as well take the government money now and get the works done. It's based on whole house approach. So it's solid wall, cavity wall, underfloor insulation, loft, pitched roof, flat roof, rooming roof insulation, air source, ground source heat pumps, solar thermal, biomass and hybrid heat pumps. And I didn't know that straight off the top of my head. I was reading that script. But those are the things that it will cover. You might as well take advantage. You're going to be forced to do it in a few years' time. Interestingly, we are starting to see, and this is something that I was talking to Rightmove's Director of Data Services just last week on, we are starting to see that more energy efficient properties are just ticking slightly higher in terms of their value. So rental value and sales value. Marginal, it's within the margin of error, put it like that. So we're not saying it does improve the value of properties, but there is certainly, we are now starting to see some evidence that more energy efficient properties are attracting higher premiums. So something you might want to factor in, you might want to talk to your landlords, get ahead of the curve, get them up to the C's whilst the government is giving you 2/3 of the cost. Because it is basically free money. So we're paying for it. Our taxes are going in and they're giving, you might as well take as much as you can out at this point in time. So I would say it's a no-brainer. There are no strings attached. You apply for the voucher through gov.uk. And as long as you have completed the works and had the installation within 3 months of issue or 31st of March, 2022, whichever is later, they will just give you the money. So I personally think it is a no-brainer at this point in time.
Thank you. And quite a good way of getting money flowing back through the economy as well.
Absolutely.
As we exit the pandemic. I'm conscious that we want to leave sufficient time for questions, and just as a reminder, please put them in via the Q&A. My colleague Remy, who accidentally, I believe, briefly flashed up on the screen for some of you, and runs our webinar series, is back in the background moderating the questions and bringing them together. So we'll go to those after the final section. So we're now looking at future developments, and there is a lot coming down the track. Maybe we can deal with them in a sort of whistle-stop fashion. So the budget came out earlier in the month. What do you think how do you think the government's plan will affect agents, landlords and tenants? What are they planning, and how are they using tax and changes to affect that?
Well, let me give you some stats to start with. Within an hour of the Chancellor announcing the SDLT, the stamp duty change, use of the mortgage calculator on Rightmove went up by 85%. That is how many people hit the site within the hour after that announcement. And it's something we are seeing. We've had our record highest hit rate of any day this year in Rightmove's history. The number of leads coming across to you as agents, the number of hits on the website are absolute all-time high. So what the Chancellor has done, what the government has done, has had exactly the impact that we were all hoping for. It really has invigorated the market, and the stats that I see every day of traffic to the site really it's a huge indicator of how active the market really is. So actually that was really positive. What we didn't see is effectively how are they going to pay for the 250 billion pounds or 240 billion pounds that they've just given out. They can't just keep giving out money. They are going to have to start taking it in sooner or later. So there wasn't anything on the expected changes to capital gains tax and the increases to capital gains tax. Maybe that's coming later. There wasn't anything on income tax and the potential that was being discussed about changes to income tax. So I do wonder, and this is just my speculation, the world according to David, did they give a nice, fluffy, warm budget because we're still in the midst of the pandemic and the mean stuff is going to happen somewhere later down the line? Probably. But we've got good stuff. The mortgage loan scheme as well, the 95% loan to value ratio, that's great news as well. Stamp duty, definitely, it's saving people thousands and thousands of pounds. And it really has reinvigorated the market. So in terms of budget and finances, taxes, things are inevitably going to change. They've got to start recouping some of the money that they have spent. And don't get me wrong, personally, I think what they've done was absolutely the right thing. It's kept the country on its feet as much as possible over the last 12 months. But we are storing up unimaginable amounts of debt for the next generation to pay for.
And I guess from a policy perspective, that makes sense because, let's say the example of an accident, it's the bones are still fusing back together. It's too early to do the physio to get back to full mobility, and we need to go through the recovery process first before we get back to full health. So that makes sense. So looking, I guess, more specifically,
really good analogy. I like that.
Looking specifically at the letting sector, so let's call it 14 months ago, so 12 months since the state of lockdown sort of began. 14 months ago, we were all focused on the Renters Reform Bill and ROPA. What do you see happening with each of those, I guess, separately, and what could or should agents be doing now to prepare for them?
So I think both of them are coming. I think they're both inevitable, one positive, one less positive. The Renters Reform Bill will probably come first, because it was in the manifesto. It was a key part of the Conservative Party's ask and appeal to a younger generation and generation rent. So that is more developed at this point than the recommendations from ROPA, but I still think ROPA is going to go forward. It's just that there have been higher priorities with dealing with the pandemic over the last 12 months than moving that forward. So I think especially MHCLG has been one of the government departments that has really been on the forefront of tackling the coronavirus pandemic. A lot of the team members that I used to deal with on a very regular basis were just completely taken off what they did and not replaced and put onto the coronavirus pandemic response. So just to give you an example, the person that is leading the coronavirus response at MHCLG is the very same civil servant who took the tenant fees bill through Parliament. So she was taken off PRS matters, put on to fix the pandemic work. So that is why we haven't seen a huge amount, because they have, I used to speak to the officials on an almost daily basis, and they were focused solely on fixing the pandemic, dealing with the issues as they were coming in. They were incredibly responsive. So a lot of the time, I'm not the most positive person towards certain government actions, but I would say, having engaged with the civil servants over the last 12 months, they have been working absolutely flat out to make sure that the country could keep functioning. And it has meant that what they were doing before the pandemic, they've forgotten about, and they're going to have to go back to at some point. So ROPA, absolutely. Renters Reform, absolutely. And we've just got to get prepared. None of it is going to happen quickly. They both require primary legislation. So we've got probably at least 9 months through Parliament once we get parliamentary time back for actually doing this. Because if you remember, it was actually in the Queen's speech in 2019 when the new government was introduced. And we had the very first Queen's speech, my government shall, whole list of things. And then the apocalypse happened and everybody forgot everything that happened in that Queen's speech and nothing has been moved forward. So I think if we have a new one, I'm not quite sure how they've extended this parliamentary year. So when we get a next one, we will probably get it back again. We may well get ROPA as well. And then we will go on. But we're still talking really years away at this point in time.
Okay, thank you. A couple of, I guess, quick fire things. So I have seen various comments, questions about pets and I guess specifically the impact of the model tenancy agreement. Would you be happy to talk through what, if anything, has changed in respect of pets? Because I think there's some misunderstanding in the market.
Sure. Yeah, well, pets, that's an interesting one because actually it hasn't really changed a great deal. So what's happened is they've introduced a new pet clause into the model tenancy agreement. You don't have to use it. Most people don't use the model tenancy agreement, but most pet clauses at the moment in most tenancy agreements say no pets without the express prior written permission of the landlord that shall not be unreasonably withheld. What this says is no pets without the landlord's written consent, but consent will be deemed to be granted if the landlord doesn't respond within 30 days. So really, the only difference is adding this 30-day bit in, that if you ignore the request, it will be automatically granted. So it's not changing it a huge amount, slightly reversing the syntax on placing the burden on the landlord to respond, but not really that much different to where we are at the moment. But once again, talking about direction of travel and sort of where are we going from a policy perspective, I think it's really key that this is something that is being talked about. There's also a bill going through Parliament at the moment that is legislating to allow somebody a right to have a pet in a property, not just private landlords, social landlords, blocks of flats as well. It's unlikely to get anywhere. It's a private members bill. It was introduced in October, I think, last year. Hasn't even got the date for its next stage through the parliamentary process. So it's had stage 1 of 10. Hasn't got a date for stage 2 of 10. It's unlikely really for it to get anywhere, but we are now seeing this discussion. So it's something that I would suggest agents want to be thinking about. How do they deal with the pet issue going forward? And that arbitrary no is probably not going to work for much longer. So how do we embrace pets in the private rented sector without the need for a massive legislative stick? Because if we get that, it's going to be blunt. So let's try and find a market approach to the pet problem rather than waiting for a legislative stick.
And also understanding the context, because this has been relatively widely reported in the mainstream press. And so understanding the context is pretty useful if you are presented with a tenant who said, I now have a right to have a pet. And I guess sort of realigning their expectations about what the model tenancy agreement is and isn't, and whether or not you use it. Conscious that we've got a couple of minutes until we're going to kick into questions, but UK GDPR more generally, data protection and data security. The whole landscape changed immeasurably with GDPR. It has changed what I'll describe as subtly so far under UK GDPR, with the prospects of further change coming. David, what's your view on what agents should be considering?
So data protection is becoming a really important issue. People are becoming very aware of their privacy rights. Luckily, we have had what is known as an adequacy decision with the EU, which means that we are still allowed the free flow of data and personal data backwards and forwards between the UK and the EU, and of course all the other countries that the EU has an adequacy agreement with. So there were about 15 of them. Have had changes with transferring data to the US. So one of the things I would suggest is that people look at where is your data going. So where are the data centers for some of your CRM systems? And if they're going to the US, just be a little bit careful, because there are laws in the US. There is the Patriot Act. There's also something called FISA. which basically allows the US government to take data on the basis of terrorism and combating terrorism, but they don't know what the data contains without seeing the data, therefore they take everything. So it's being judged incompatible with GDPR and obviously UK GDPR as well. And therefore there are difficulties with transferring data between the EU and the UK and the USA. So just think about where your data is being held. Always look for UK data centres so that you don't need what are known as special contractual clauses. If you are transferring data to the United States, you need to include in your customer contracts what are known as the standard contractual clauses. They're called SCCs. They are available on the ICO website. You just literally fill it in. They are agreed wording set by the European Union in agreement with the UK government, and they work with all third countries. So a third country is a country that is not the UK or the EU or the other countries that have got an adequacy assessment. So if you're transferring data to India, Australia, the US, Canada, all of these countries, you need to start building these standard contractual clauses into your data streams and your contractual architecture. Otherwise, technically, you're going to be in breach of GDPR. And I think this is an area that is just going to get more and more serious as we go on, because people are sharing much more private information. We're asking for much more private information, sensitive information in forms that we are filling out online. And therefore, where that data is going and how that data is being stored is becoming really, really important. And I know it's something that us at Rightmove, who have huge repositories of personal data from the people that send leads to you, we have to be very, very careful with what we are doing and how we are storing that data. And because we are a large company that is thinking about this, we want to make sure that you, our customers, are also thinking about it and are protected as well, because the fines are huge, number one, and the reputational damage for data breaches is immense.
Brilliant, thank you. And just to say, I'm assuming there are a reasonable number of Fixflo clients on here today. To save our DPO responding to each of you individually, our databases are within the European Union. In the event that, which is allowed under the adequacy decision, in the event that adequacy is removed, we will move UK clients' data back to the UK and move to a UK data centre. So hopefully our DPO doesn't get the same question multiple times off the back of that. But I'd like to know.
Following on from that, I would say Rightmove is also stored within the United Kingdom as well. So as Rightmove's data protection officer, I can assure you all the data is held and remains within the UK.
Excellent, thank you. And so on to the questions. There are a lot, so apologies if we don't come to all of them. We're going to do our very best to pick up the themes. And there are a lot around Section 21, Section 8 and possession. So I'm going to sort of consolidate a group of them into a broad question, which is, in the event that, as you believe and as has been intimated, Section 21 will be abolished as a process for regaining possession, do you have a steer or insight on what is going to happen in respect of Section 8 or some form of accelerated process for recovering possession in the absence of Section 21 without the need for a court hearing?
I think that's a really important question. And I hope that is what we're going to see, because just banning Section 21 on its own is going to be a bit of a nightmare. And certainly all the conversations I've had with government over the years that this has been mooted and discussed. And I would say they started talking about this when I was actually back at the National Landlords Association over a decade ago. So it's been another one of those kind of impending disaster that you kind of, like a glacier moving, but we're now at the point where we've got to deal with it. I think that they will amend Section 8 to make it more workable while simultaneously banning Section 21. That is what they have pledged to do. We are hoping they will also take the opportunity to review the court system. One of the things I know I've argued very strongly is make it a lot more automated. If you don't, for mandatory possession grounds, you don't need an oral hearing, because if you tick the boxes, the judge has no leeway but to order possession. And therefore, does it need to be oral hearings? Does it need to be in-person hearings? Does everybody need to go to court centres any longer? Yeah. We're seeing the administration of justice is happening online. Every other part of our society is operating online at the moment. Do we need to do it in court? Can we get, there is possession claims online, PCOL. It's awful, awful system. So let's sort that out, make it better, make it so that you can't make the silly mistakes that I know lots of people do by putting the wrong dates that then gets cases thrown out of court. Let's have a system within the Ministry of Justice that actually stops those silly mistakes, so that you can't put the wrong court date, the wrong notice date and the wrong eviction date and all of those on the forms, so that it's speeding up justice. We're obviously talking very much about specialist housing courts and the specialist judges that actually deal with housing law, rather than needing lawyers to go in and explain to the judge what the housing law is. So, there are things that can be done. There are things that should be done to just make the process more efficient and to operate in the 21st century. And that's what we need. We need an efficient court system that can operate in the modern world, not a system that worked fantastically in the 19th century and hasn't really been updated since, however pretty the buildings may be.
Thank you, David. I've got a horrible question that I'm looking forward to asking you, which is, in the event of bailiffs being instructed, what can or should agents be doing? Or is there in fact any policy that you see coming over the hill to prevent tenants from simply saying that they are self-isolating or similar, to prevent the bailiffs regaining possession?
That is a very good question, and one, no, I do not know the answer, because I don't think at this point, because everything is all about on hold, I think we will get more guidance on that one post the tapering, once we start knowing what the guidance is going to be about the tapering. We're also moving very rapidly in terms of the vaccination program, and they're talking about pretty much all of us being vaccinated by the end of summer at this point. So when you think 14th of June, they're talking about July, August in terms of the vaccination program, so, or at least first dose vaccination program. So there's not going to be, you're going to be in that gap. So less people likely to be self-isolating at that point in time. But that's just my speculation until we see the guidance. I really don't know.
I'm going to come on to EICRs again. We've got a lot of questions, so apologies if we don't come to yours. We're trying to pick out those which have been asked by multiple members of the audience. So the first is, who is liable for the lack of provision of an EICR? Does the liability remain with the landlord, or can it be subrogated to the agent?
No, EICRs are one that it's the landlord's responsibility. There are not provisions like there are with licensing, so selective and additional licensing, where the liability can be transferred onto the agent. So it will be the landlord that's liable.
Well, one that I don't quite understand, but it seems to have come in from two participants in the audience. So what happens if the EICR is issued in the tenant's name and the tenant changes? My understanding was the EICRs were issued, or those that I've seen have been issued in respective properties. Do you have a view or an understanding of that?
I have to be honest, my understanding as well was they were issued to the property, and it's about the property's electrical condition, not the use by the tenant. It might have the tenant's name on it, at which point that does cause slight data protection issues. So you might have to redact that when you give it to the next tenant. Otherwise, you will be passing on personal data. So this might be one which is more of a data protection issue rather than necessarily an EICR issue. So the EICR, valid for 5 years, and it journeys with the property, not the occupant. But if it has got the occupant's name on it, that's not the landlord's name, you might have data protection issues passing it between, because then you're passing personal data without the original tenant's consent. So you might have to just redact that. Tipex.
A practical question on EICRs. So if an agency has been carrying them out for a period of time, ought they be reserving, or in fact possibly serving, the EICRs on the tenants where they may not have previously done it. So they've got the evidence. So if they've been doing them for 3 years as a matter of course, my view is they ought to be resending them to the tenants in an evidenceable manner, so that they've got all of their audits ready. But is there any reason why they would not do that?
No, that is a good idea. Like that idea. All I would say for older EICRs is that they're fine. So what it does say is it has to be up to the 18th wiring edition, the 18th edition of wiring regulations. I will get that correct eventually. But they came into force basically on the 1st of January 2019. So anything done post 2019 will be fine. If you've got ones that were done under some of the previous versions, as long as you've got no hazards, it should be fine to last out the 5 years. But if they've got hazard warnings, then you probably need to address them and probably get a new one. And those are C1, C2 and FI hazards, rather than F1, which I made the mistake on last week's webinar. I meant FI, not F1.
Just as a reminder, there is a flow chart that we have. We may be able to, depending on whether it's already been put together, a flow chart that we did with David Smith from JMW Solicitors, which goes through all of this with the associated legislation. So if we don't manage to get it in the follow-up email, please go to our website, have a look. It's freely downloadable for you. I'm going to come on to breathing space. I'm not sure you'll know the answer to this, but if someone takes out a breathing space or takes advantage of Debt Respite Scheme, will it have an impact on their credit rating?
No, it won't. So that is something that is specifically written into the guidance. It won't impact their credit rating. The debt might. The debt will have an impact on their credit rating, but the fact that they've taken advantage of the breathing space scheme won't. Especially, I would imagine, if they get to restructure their debt and pay it off, it might actually improve their credit rating.
A comment, and I note that I asked for comments, but I haven't tick through many of them. Will the government give any consideration to the mental health of landlords and their children who are facing bankruptcy and the relentless hate propaganda? That's not a question, David, so you don't need to comment on that, but it was a comment that was put in. We have separately dealt with the right to rent procedure. I think there is guidance on that on our website. A couple of questions have come up on right to rent, although it wasn't specifically mentioned on this webinar. David, is there anything else that you would like to point out?
Sorry, I missed that, Raj. Would you mind saying that again?
The right to rent procedure, so virtual right to rent, and then taking doing in person at the point at which lockdown ends. Where would you point agents who are still unclear about what the rules are?
So yes, the temporary measures on the right to rent are, I'm sorry, I can't remember the exact date they came into force last year. It was end of March-ish. They are still in force. They will be in force until further notice, until the Home Secretary makes an order reversing it back to what it was. So you can continue doing that. You will just make sure you are keeping a note of all the tenants that you've done that with, because once we go back to normal, you will then have to go and fill out the physical right to rent check or follow-up check, depending on the nature of each tenant. So do make sure that you've got a file note of which tenants need full right to rent checks and or follow-up checks, because we've now been over 12 months. So do think about that. Also think about the new landlord checking service that is available, where you then don't need to do the check. So it's available on the Home Office's website. So it's a more sort of up-to-date version of the original landlord checking service, which is dealing with foreign nationals. So you will be able to look at that, and if you get a positive readout from that, that will be absolutely fine for the right to rent check purposes. So yeah, if you look at gov.uk, there's loads of explanation about the new right to rent checking service that is available on gov.uk.
Brilliant, thank you. And I'm afraid we're out of time. I would ask all the audience if you could take a moment to just provide feedback. So we're reshaping our webinar series, so we'd love to hear from you. Apologies if we didn't get to answer your question, but thank you very much for tuning in. David, thank you so much for giving up your time and sharing your insights with everyone. It's been an absolute pleasure. For anyone who's interested in following this webinar series, we've got some on YouTube. Please follow the channel or follow us on LinkedIn to be notified as new webinars are going live. And again, so new webinar series, we are kicking off with David Smith, a quarterly legal and compliance update for letting agents. It's on the 28th of April. If you would like to know, and this is not about policy, this is specifically about law, please do tune in. And finally, just thank you once again for giving up your time, for sharing your insights with us. And also, David, thank you very much. Really grateful. Have a wonderful day, everyone.
Thank you very much. Bye-bye.